Everybody tells new business owners, focus on marketing, focus on growth. In healthcare, that advice gets people shut down. The real secret to surviving your first year isn't growth at all. It's hitting 3 quiet legal milestones that make growth possible. I get why that sounds counterintuitive. Most people don't want to think about law until there's actually a problem. But I've watched clinics scale past $1 million because they nailed these basics early, while others collapsed because they skipped them. And today I'll break it down step by step. Let me tell you about a story when a medical spa came to us to sell. And we were all excited. You know, everyone's going to make a bunch of money, hopefully. And we did a little digging and we were doing our due diligence. And turns out the sellers of the business had chosen the wrong entity. In addition to that, unfortunately, the husband of the nurse practitioner was not licensed. And so what that meant is before we could even sell, we actually had to go back and fix the entity itself, which is very expensive. It also knocked down the purchase price because the buyers said, well, now there's a lot of risks. The state could come and look at what was organized improperly before, and we had to navigate that entire transaction. Now, sellers weren't thrilled, but lo and behold, they had filed the entity by themselves. Not a big deal. You know, they went about 10 years without the state knocking on their door, without the boards knocking on their door, without really any technical legal issues. But now when we went to sell I think that sale was multi-million, probably 4 or 5 million, that got knocked down and severely delayed because we had to do a lot of cleanup. So the moral of the story here is, had they spent just a little bit of time on the front end picking the right entity at the beginning, this could have all been avoided. And so there are a few different key entities when you're in healthcare. LLC, professional limited liability, and corporations. And they're a little bit complicated because in medicine and healthcare, there's what's called the corporate practice of medicine doctrine, which generally says, depending on the state, that only licensed healthcare professionals can actually own those entities. Now, on top of that, I will say these sellers did one thing right. They filed an entity in the first place. And why that's important? It's because it actually protected their personal assets, assuming that they were actually operating in the business itself. So they made the right decision there. And they also made the right decision to be taxed correctly. It turns out they had consulted with a CPA and they made an S-Corp election, which for them saved them a lot of money over the life of the business. The only thing they did wrong, which came back at the time of sale and cost them a lot more than it should have, was actually choosing the owners of the entity incorrectly. So once the entity is in place, the next milestone is making sure that your compliance foundation is solid. All right, now for compliance. Let's say you work at a med spa. You're a worker there, all right? You're following their training, you're doing their policies and procedures, but you have a little bit of a falling out with the owner. You don't see eye to eye on something. Maybe you don't like the pay structure, and all of a sudden, you decide to leave. Now, there wasn't anything technically that was wrong with your job position, but it turns out in terms of HIPAA compliance, you noticed that this company wasn't really following everything internally. And so what you do as the disgruntled ex-employee is you go and file a complaint with the Federal Department of Health and Human Services. That's who's in charge of regulating HIPAA. And then they come knocking on your door and they're saying, hey, we have a credible allegation that you either don't have policies or you're not following them, straight from a staff member. Plus, that staff member also pointed out a lot of technical violations where, you had software that wasn't HIPAA compliant, or you were posting photos on social media without written consents because they were the little detective that was in there as the employee beforehand. Believe it or not, this happens all the time. People believe that HIPAA violations primarily come from patients. It's not true. They actually are usually coming from staff or jealous competitors. I've seen that quite a bit, that are reporting violations to the federal government that they are largely obligated to go and investigate. And now all of your policies are under scrutiny. So right out of the gate, it's really important for an entity. And for a lot of entrepreneurs, this is the first time they've actually had to, read and understand HIPAA head to toe. right out of the gate, you need your internal policies and procedures, HIPAA, OSHA, patient procedures, everything. And where that is important is that not only do you need those, you need to actually follow them. As a small business, you're the biggest target for compliance issues. Big organizations, they have armies of lawyers and compliance teams, okay. But you as a smaller business, and when I say small, I'm going to say under 10 million, you don't have all of the resources. You need to be smart about these, and they're not that hard to miss. Now, I'll also say this, even if you didn't follow to a T your policies and procedures, the board or anyone investigating you or when you're in a legal dispute of sorts will be much more, I'll say, happy or forgiving if you actually had a policy in place in the first place. And I've worked with large companies that didn't have an internal HIPAA policies and procedures manual. They had a notice of privacy practices, which they handed to patients, but they had no rules or training on how to tell their staff what HIPAA actually was. And so if I said to them, what is your HIPAA training, or what would you actually do in terms of a breach? They had no idea. And then of course there is a breach, and on the first time they get with a big hit or a threat of a fine. And so don't let yourselves get tripped up by something that's easy compliance. So don't let compliance be the reason that your business is under threat or is responding to a complaint from the federal government. It's a really easy milestone to hit in that first year. And now that compliance is in place, the third milestone locks down your protection. It's your legal contracts. Legal contracts. So we get calls all the time from healthcare business owners, and they signed a lease, which basically has them dead to rights. And lo and behold, they didn't have an attorney look at it. This always fascinates me because if you look at the monthly price that they're paying plus the term of the contract, these contracts are actually worth more than a house, right? These are in $300,000, $500,000, or even $1 million leases, and you skipped on not even having any sort of legal review in the beginning. And so if you're starting up in that first year, it's absolutely imperative that you, at a minimum, have a lease review. And the reason I'm focusing on lease reviews is we just get so many calls when clients are halfway through a lease and they're having issues with the landlord. And we say, all right, send us a copy of the lease. And we look at the lease and it is very pro-landlord, as it probably was designed to be. And the landlord presents it as it's non-negotiable and, you don't really need an attorney. And, this is a take it or leave it. And that's not true at all. Or you should walk away and have had multiple options. And so the moral of the story here is signing restrictive agreements early in your business life cycle can absolutely handicap you later on. This isn't just with lease agreements. This could be in the medical space. It could be equipment financing. So you're purchasing a laser of sorts. You don't have the ability to pay for all of that out of pocket, so you're financing it. But then there's all these little restrictive terms that are buried inside of there that we only learn about when the device breaks and you can't use it for 6 months and you have no recourse. At the end of the day, it's very tempting to just run into all of these contracts right out of the gate. You're brand new, you want to get up and running, but we need to play the long-term game. And that's the way that we think at Holt Law, right? We're playing the long-term game. So if you're signing a lease, right, we're thinking about that both in terms of growth and the success of your business long-term. There should be provisions in there for us to be able to exit or get the landlord to fix stuff or be able to at least negotiate some of the terms and not just to take it or leave it, because who knows where your business is going to be in the next 5 years. We don't want that restrictive lease to be the thing that's weighing us down. So all in all, once you've locked in your contracts, you've hit all 3 milestones that separate risky clinics from secure, scalable ones. Now that you know the 3 milestones to hit in your first year, the next step is understanding how to actually launch a medical spa the right way. That's exactly what we cover in the next episode. Don't miss it.